management prerogative. So when we say about termination, it is basically the action of bringing something or coming to an end. But we put it in a certain situation, there are certain grounds. First, a just cause. Second, an authorized cause. And third, when he fails to qualify as a regular employee. Let's talk about the just cause. Just cause is always based on the acts attributable to the employee's own fault or negligence. Normally, it is employee attribute. For the second ground, an authorized cause, it is a lawful ground which in general do not arise from any fault or negligence of the employee. Basically, there are two kinds of authorized cause. First is business related, and the second one is health related. Under business related, examples are retrenchment, installment labor, saving devices, redundancy, and closure or cessation of business operations, while under health related, example of this is the medical record. And for the last ground, when he fails to qualify as a regular employee. Every company has its own standards to how it qualifies their employees to be regularized, meaning if the employee does not exceed the qualification and does not meet the standard provided by the company, then he fails to qualify as a regular employee. Employees' work-related procedures, laws, and regulations must be always fair and equitable, and resulting sanctions must be lawfully enforced. This how will guide every exercise of the management prerogative.
Serious misconduct. In connection to the termination by employer, just cause in terminating an employee. A serious misconduct does not warrant the termination of the employee. Why? Because a serious misconduct is an action bringing the effect of destroying or undermining the relationship of trust and confidence between an employee and an employer. For serious misconduct dismissal, the employee must be present at this following. Number 1, it must be serious. For example, use of illegal drugs at work. According to Republic Act No. 9165, an act of instituting the Comprehensive Dangerous Act of 2002, repealing Republic Act No. 6425, otherwise known as the Dangerous Drug Act of 1972 as amended, providing funds, therefore, and for other purposes. By that, the employee must go on some legal process like drug tests to investigate its case. However, if the employee's result tests positive, that's the time that the employee can be terminated at work. Number 2, must relate to the performance of the employee's duties. For example, theft, fraud, and dishonesty. Dishonesty of any kind including knowingly mispresenting or giving untruthful information, falsification of company forms or records such as application forms, expense forms, etc., or irregular practice in respects of cash and records. Number 3, show that the employee has become unfit to continue working for the employer. For example, harassment and behavior that endangers the health or safety of the employee and others. Threatening behavior includes physical action, contact or injury, general, oral, or written threats to people who are as well as implicit threats.
Gross and habitual neglect of duty.
When there is a gross and constant disregard of obligation, DO number 147-15 given by the Department of Labor and Employment, put forward the measures that ought to be met before the gross and constant disregard of obligation might be truly utilized as worthy motivation for end. Indeed, there must be disregard of obligation, and the negligence must be both gross and constant in character.
For example, habitual absenteeism and tardiness comprise gross and constant disregard of obligation. Rehashed demonstrations of non-attendances without leave and successive lateness reflect apathetic demeanor to and absence of inspiration in his work.
Fraud and willful breach by the employee. The two separate grounds of termination are: number 1, fraud; number 2, willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. Number 1, fraud; wrongful act for financial and personal gain. Number 2, willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. The employee concerned must hold a position of trust and confidence. The two classes of employees. Number 1, employees who occupy positions of trust, managerial employees. These are who were vested with the powers or prerogatives. Number 2, employees who are charged with care and custody of their employer's money and property. Commission of a crime or offense by the employee of trust reposed in him by his employer or duly authorized representative. An employee may be terminated if he committed against: number 1, his employer; number 2, family member of the employer; number 3, or any authorized representative of the employer. They are immediately terminated when an employee committed an offense against employer, such as the closing or cessation of operations of the establishment or enterprise, unless the closing is for the purpose of defeating the intention of this law. Serious misconduct, gross and habitual neglect by the employee of his duties, fraud or willful breach by the employee of trust reposed in him by his employer and representative. The second one is when an immediate member of the family of the employer is somehow had been done a crime or offense by the employee against the person of his employer or any immediate member of his family or representatives and other causes analogous to any of the foregoing. And lastly is the duly authorized representatives of the employer. There must be an attack or employment of force or serious intimidation upon the person or the victim. It includes any offensive or antagonistic movement of any kind, with or without a weapon. This may be an actual physical contact or instilling of fear or threat, evil of a person of the victim, but not on his property.
Authorized causes. Rejection of workers requires the recognition of the two Cruz fair treatment imperatives, namely substantive and procedural aspect. The substantive aspect, it implies that rejection must, for any of the admirable motivation gave under Article 297 of the Labor Code or the organization rules and guidelines declared by the business or approved causes under Article 298 of the Labor Code. The procedural aspect, it implies that the worker must be concurred fair treatment, the components which are notice and the chance to be heard and to guard himself. A dismissal based on just cause implies that the worker has submitted an illegitimate demonstration or exclusion. The examples are installation of labor-saving devices, redundancy, retrenchment, closure, or cessation of business operations.